Anti-abortion protesters rallied outside the U.S. Supreme Court Tuesday as Kentucky Attorney General Daniel Cameron appeared inside. For more than an hour, his office in the ACLU argued in front of justices at issue whether Attorney General Cameron can appeal a lower court's ruling striking down a state abortion law after his Democratic predecessor declined to appeal.
If we prevail, we've been knocking on the door of the Sixth Circuit Court of Appeals. We want that second bite of the apple to continue defending House Bill 454.
But the ACLU argued Cameron was too late.
Really, we're seeing just an 11th hour attempt here to bring back a lawsuit that has already been decided by the courts twice.
House Bill 454, which passed in the Kentucky legislature in 2018, would have banned a common second trimester abortion procedure called dilation and evacuation. The EMW Women's Clinic sued to stop the law from taking effect and won after a federal judge sided with the clinic. A three-judge panel of the Sixth Circuit upheld the ruling.
We want to make sure that we're able, as the justices noted, to exhaust every opportunity on appeal.
Cameron's attorney argued it should be up to the state to set their own abortion laws.
I think the theme of the argument was state sovereignty, that states get to structure their systems of government to defend their laws in the way they see fit.
The decision now rests in the hands of the Supreme Court justices. It's one that will have an effect not just in Kentucky, but potentially throughout the country moving forward. Both sides wouldn't comment which way they felt the justices were leaning, instead saying they're looking forward to when they make a ruling. I'm told a ruling could be made anywhere between now and June of 2022. I'm Shaquille Lord, WLKY News.